Welcome to the Cyber Risk Management Podcast. Our mission is to help executives thrive as cyber risk managers. Your hosts are Kip Boyle, CEO of Cyber Risk Opportunities, and Jake Bernstein, Cybersecurity Counsel at the law firm of Newman DeWars. Visit them at cyberriskopportunities.com and newmanlaw.com.
So, Jake, what are we going to talk about today?
Today, Kip, we're going to talk about the revisions via amendment to the Washington State Data Breach Notification Law. Governor Jay Inslee signed House Bill 1071 into law on May 7th, 2019, and will modify RCW 19.255.010 and .200.
Sounds like an IP address. Keep going.
It does, doesn't it? So while the Washington legislature did not get its big GDPR project completed, the changes to the data breach notification statute are still quite significant.
Okay, so you and I live in the great state of Washington. Love it here. Don't ever want to leave. But I know that that a large chunk of our audience does not live in Washington State and is probably at this point saying, I don't even know why I started this episode. So let me ask you on their behalf, should they keep listening to this?
Yes, they should. First, businesses that operate nationally often must keep on top of all data breach statutes, including the 49 other states where they are not headquartered.
We'll have to dig into that later.
We will, yes. But second, the Washington amendments are instructive for everyone because they show the evolution of privacy and security legislation, even when states fail to pass sweeping regulations like the presently on hold and GDPR-inspired Washington Privacy Act.
Okay, so I think what you're saying is that Washington State lawmakers got really ambitious. They loved GDPR and they said, we want one, but they didn't quite make it. So in lieu of that, we have these amendments. Is that pretty much it?
Pretty much, yes.
Okay, but there's a lot to unpack.
There's a lot to unpack for sure, definitely.
Okay, all right. So, so is that why this law was amended? And what was wrong with the old law, or what did the old law didn't do? Please explain this.
Okay, so one, it's difficult to say exactly why they chose to amend the law this year. It's never clear, but my suspicion is that it had something to do with the GDPR law not going through. So
okay.
You could consider it a consolation prize, but I'm not actually sure if the sponsorships were the same. So really quick, if you don't know how legislatures work, basically every bill has to have a sponsor, and sometimes those sponsors will sponsor the same bill multiple times, year after year after year, if they don't pass, or sometimes they'll sponsor a whole bunch of bills that are related. And I suspect that's what happened here.
Okay, so I'm a man of a certain age. I remember Schoolhouse Rock on Saturday morning. I'm just a bill. Yes, I'm only a bill.
I know.
And that was
it's really too bad that
I learned so much from that.
Yeah, it's still true.
Okay, so if nobody knows what I'm talking about, go to YouTube after this episode, look it up. It's Schoolhouse Rock, How a Bill Becomes a Law. It's this great little cartoon ditty. Love it. And that'll bring you up to speed with what Jake just said. Okay, let's keep going.
All right. So the real question here is, what did they do to the data breach notification law? And I'm going to give you the high-level bullet points first, and then we'll drill down a bit and discuss the implications.
Great.
So first, they dramatically expanded the definition of personal information. They modified the method of notification, and they introduced additional content requirements for the notifications that you're sending. And then just in case that's not enough, they also reduced the time permitted for notification and created a new requirement for updating notifications to the Attorney General.
Okay, so that's actually a pretty big amendment. That sounds like a lot of substantial changes, and it also seems like an overall toughening or strengthening. Seems like it is going in the direction of what you had said before, which is, their dream was to have a Washington State GDPR. Okay, so let's start looking at these 5 different points, can we start with something simple, just kind of ease into it?
Yes, here's the simplest one. Instead of 45 days to issue notifications to affected individuals, you now get 30.
You know, as an information security professional, clinically speaking, I like this. However, as a chief information security officer, this kind of annoys me because 30 days is barely enough time to do anything in the business world. 45 days seemed like not enough, and now there's only 30. And I just wonder if the legislature really understands just how hard that is.
Well, so the update, the new update kind of allows you to give notifications in stages. And I think the idea is to get the information to the affected individuals as soon as possible so they can protect themselves. Given that, I'm not sure that I disagree with this change. I mean,
Uh-huh.
it's only 15 days, but a lot can happen in just over 2 weeks.
Okay, well, I could also call it a 33% reduction,
It
right? Now
is.
it sounds really big. And, as a former assistant attorney general, I got to think you like this too, right?
So the attorney general has to be notified when there are 500 or more Washington residents affected by a data breach. And everything we're going to talk about uh, applies to that. So if you have to if you have to notify the attorney general, then you only get 30 days as well.
Okay. Well, so if I'm a CISO and I'm trying to figure out how to comply with this law, the first thing I'm going to figure out is how can I maximize this 30-day window. And so I'm probably going to figure out how to take the time that I need before the 30 days notification timer starts. That's probably what I would do. Is there anything in this amendment that you know of that would prevent me from taking that tact?
Well, let's move on to the expanded content and then we can figure that out.
Okay, yeah, that sounds good. All right, so we know that the notification has just decreased. Okay, so is there another easy one?
Not really.
Okay, which is the next less hard one? Is that a good way to say it?
It is, and I'm actually going to give you a twofer here. So the new law makes changes to both how you notify affected individuals and what content you have to include in the notification.
Okay, that might be good because sometimes these laws are super vague and you have to struggle to figure out what to do. So
Well,
walk us through
you say that now, but just wait.
it. Wonderful. Be
Okay,
careful what you wish for.
yes, the method change is fairly simple, convenient, and I think most businesses will really like it. So here it is. If the breach involved a username or password, the breached entity may provide notice via email.
And not something through the postal service, like just email?
Just email. And this is a big deal because, as we both know, postage for breach notifications is one of the largest expenses, just administratively.
Yeah. Well, and everybody's attention these days is going from hand delivered letters to email, right? I mean, everybody that I do business with wants to send me emails. Nobody wants to send me a piece of paper anymore.
Now, there is a caveat. If the breach involves the login credentials of an account furnished by the entity, then you cannot use the email. And I think we know why.
Okay, so the Postmaster General, first of all, is breathing a sigh of relief. I could guess why. Is it because maybe I can't receive an email notification because my account was hijacked?
Correct.
Okay,
Or
point. I got a point.
even worse, and I've seen this happen, bad guys will set up filters on your email so you only get the email that they want you to get.
Right, and so if there's filtering out and breach notifications and whatnot, then you're going to remain clueless. You're going to live in your bubble of perfect security and be fooled. Okay,
Yes,
yeah,
you're
that
right.
makes sense.
Okay, so now we get the fun one, the content. So the notification itself must, and this is a quote, inform the person whose personal information has been breached to promptly change his or her password and security question or answer as applicable, or to take other appropriate steps to protect the online account. Now,
Okay.
this is great. It's not quite finished. The that is with respect to the breached entity. But
Hmm.
you also have to tell the person to take care of all other online accounts for which the person used the same username or email address and password or security question and answer.
Oh, that's
So,
actually really good
so
because a
what
lot of
does that?
people do that.
It is. And what does that sound like to you?
Um, it sounds like anybody who's doing that has really horrible cyber hygiene. But what else does it sound like?
Well, it to me it sounds like the legislature is getting a clue, which is good
Yeah,
news.
you're right. You're right. Yeah. I mean, it was so practical when you said it to me that I was like, finally. But yeah, the implication is that legislatures are finally starting to realize how things really work. Yeah, that's a great um, that's a great revelation.
I'm hoping that it is true. So here's the rest of the new content requirement. And this is a little scary. So you have to include details of the breach, including a time frame of exposure of the relevant personal information if you know it, and this is my favorite part, the date of the breach and the date of discovery of the breach. Now,
Ah,
now if you think about this, if I have to tell you the date of the breach, the date of discovery of the breach, and then you know when you got your notification,
yeah.
there's kind of an automatic self-enforcing thing going on here.
Yeah, this is more insight on behalf of the legislature. So, in the case of like Equifax, if they had to notify under this rule, people would have seen that the exploit had happened like 6 months prior to them figuring out that it happened.
Exactly. And now that information still came out, but it was dependent on journalists and Twitter and the
Geo
blogosphere.
reports.
Yeah, exactly. So what Washington has done, which I think is pretty interesting, is kind of creative a shame system here where within the notification, companies have to kind of cop to their timing and what happened.
Hmm. Well, that's good. Yeah, that's transparency.
It is transparency. And there's one more bullet. If the notice must be provided to the Washington Attorney General, and again, that's if there's 500 or more Washington residents, then the
Hmm.
affected entity must include that same content, so the time frame, the details, the dates, and a list of the types of information affected by the breach, and a summary of steps taken to contain the breach, plus a sample copy of the notice to the affected individual. So the AG wants a full report, and you can't really hide at all.
Huh. Well, okay. So I think this is good for people who are affected by data breaches. So I'm happy about that. But I can't help but to kind of feel a little pain in my neck as a CISO because my workload's gone up. Oh, well.
I think that will be the case. Anyone who has to deal with this new law, frankly, has a lot more work to do than they do under most typical data breach notification laws. In fact, what I have seen is that when a state can't quite get that sweeping regulation passed,
Uh-huh.
they're going ahead and modifying their data breach notification laws. And most of those are pretty old, and the scope was limited, as we'll see. And I think another reason that this is worthwhile for everyone, not just our Washington State audience, is that this is probably what you're going to see from data breach notification statutes moving forward. And I bet even in states that have zero appetite for a sweeping GDPR or California Consumer Privacy Act type of law, that you will see these types of changes to data breach notification.
Okay. Would you say that the Washington State amended data breach notification law is like one of the toughest in the country now?
I think it probably is. It's definitely among the toughest, in terms of states that don't yet have comprehensive laws.
Right. Yeah. Okay. I mean, so as a CISO, when I'm designing a program, and I know that there are 50 different data breach notification laws, it's very common to take the approach of, well, let me figure out which one's the most restrictive, the one that requires the most, and then I'll design my program around that one, because then I'm sure that the other 49 states will not be unhappy with me because I'll have met or exceeded all their requirements at the same time. So that's a pretty typical approach. Wouldn't you say so?
It can be. I think a lot of companies pay most attention to whatever their home state is, but if they do business nationally, then they really do have to kind of comply with all of them.
Right. Yeah. Okay, good. So if you do business nationally, then it's good to know which state has the most demanding requirements. And right now, that could very well be Washington State, short of a California style GDPR, right?
Yeah, Vermont, Massachusetts, a few other states have some pretty robust laws, but this one is getting there. And we're not finished yet in terms of these changes.
Oh, right, because you said there were 5.
There were 5.
And I think we've done 3 now.
We have, give or take.
Okay. So I wonder if I should just cheat and look at your notes. Let's see here. So I'm going to do that. Let me look at your notes here. So here's another change. If you don't know something about the breach at the time you must send notifications, you have to go back and update the Attorney General once you learn new information. Oh, interesting. So now the Attorney General is kind of an active member of the audience, and they now get updates. Okay. And then finally, the definition of personal information. Okay. It's not as easy as I thought it was. Here, take your notes back. You do it.
Yeah, that one is huge. Before I move on to that, I want to kind of highlight the Attorney General implications here. So this statute requires you to tell the Attorney General everything, and process is becoming a lot more important, which you like, because you always preach the importance of policy, procedure, and following through on what you're supposed to do.
Yeah, definitely.
And, with the new content requirements and this update requirement, the AG is going to stay informed. And what's really interesting is if you go to the Washington State, the Attorney General's office, and the data breach notification page, you will find a list of all the data breach notifications. And let's see, take a guess. How many do you think were sent to the Washington AG in July?
Just in July of this year?
Last month, yes.
500.
I'm sorry, specific, not like numbers of notifications, but like individual breaches.
Oh, I like 500, so I'm going to say 500. I don't know.
No, okay. It's 1,
I haven't looked.
3, 4, 5, 6, 7, 8.
Oh, just 8.
That's 8 breaches. I have no idea how many people were affected. I'm only talking about the number of reported individual breaches.
Right, and each incident could have affected millions of records potentially.
Well, we know for a fact that each one affected at least 500 Washington residents, because otherwise they wouldn't have told the Attorney General.
That's why 500 was in my mind.
That is why 500. So there's 8 times 500, so that's at least 4,000 Washington residents. It's probably a lot more than that, though.
Yeah. Okay. Probably is. Yeah.
So,
Okay. So, so the definition of personal information, though.
yeah, let's dig into this thing. So, I think this is where things get most interesting, even though everything else we've discussed is really important. So, to give some context, here's the old definition.
Okay.
And the specific definition we're talking about is personal information with a capital P and a capital I.
And this comes from the original law, which I think was passed in 2002 or 2003.
Yeah, I think that's right. It's
reached its adolescence.
Yeah. Yeah, it was amended again in 2015, but I'm pretty sure that it existed before that. But I have to check. Anyway,
okay.
Here's that definition. An individual's name in combination with a social security number, state identification card number, or financial account or credit or debit card number in combination with any required security code, access code, or password that would permit access to an individual's financial account.
Okay. All right. That's what it used to be.
That's what it used to be. Fairly specific, isn't it?
Yeah. Very specific. So, yeah, that's pretty easy to understand. It may not be easy to implement, because you may not realize all the data fields you have in your possession, but easy to understand.
Well, I also think it's pretty limited. I mean, you have to have someone's name with something like a social security number, the state ID card, or a username and password plus a financial account number.
Right.
Not that many businesses hold that type of information anymore.
No, mostly you're just talking about a bank or, something like that.
Yeah. So here's the new one. So it's the old definition plus the following. And again, when compromised in combination with an individual's name. Here we go. Full date of birth, any private key that is unique to an individual and that is used to authenticate or sign an electronic record. I think this can include like an AWS API key, but I'm not sure.
Yeah, or a PGP key or any kind of a private encryption key. Oh my gosh, these legislatures have become, I guess we have digital natives in there. I don't know what else to think.
I think we do. So continuing, student, military, or passport ID number, a health insurance policy number or health insurance identification number, any information about the person's medical history or mental or physical condition, or about a healthcare professional's medical diagnosis or treatment of the person.
Wow.
We're not quite finished. The last new component is biometric data generated by automatic measurements of unique biological characteristics such as fingerprint, voice print, retina or iris scans, etc.
Wow. Is there any more?
It does. It gets better. So if the data is not encrypted or redacted, then the requirement that the data be leaked with someone's name is removed. So let's think about this.
Yeah, please. My head hurts.
I know. So generally, you have to, in order to fall under this data breach notification statute, you usually have to leak someone's name plus some of this other data.
Yeah.
Now, if your data was not redacted or encrypted, then even if a name isn't linked to these records, this still applies.
Oh, is that because the assumption is that with that information you can readily discover the name of the individual?
I think so, yes. Now, here's one of my favorite parts. If the data, quote, would enable a person to commit identity theft, unquote, then the name requirement is also lifted. I have no idea what this really means, but it's definitely a big expansion.
Wow. Okay. Well, so, all right, anybody doing business in Washington, or as we said, if you're doing business nationwide, you certainly should become more acquainted with this, and
But
we're
Kip,
certainly
I
going to be
wasn't quite
watching.
finished.
Okay.
There's one more piece. So a username or email account plus a password or security questions is enough on its own to trigger the law. The full name is not necessary to fall under the expanded definition.
Oh boy. So all right. So these 5 bullets, these amendments, this is actually really substantial, right? This is a really substantial revision. Perhaps even massive might be the right word. Am I getting this?
Yes, you are.
Okay.
It's huge.
Okay. All right. Thanks, digital natives. All right. Well, it's good. I mean, I'm not against this, but I'm gonna have to work harder. That's all.
Well, and if you think about the implications of expanded data breach notification laws, there is huge liability for hiding something, and what you can hide is, is getting smaller and smaller. But also, the very act of sending all this information out really opens up the floodgates of litigation, as we like to say. So I would expect that these notification statutes probably will have a larger effect on security than you might realize. I think in the past, they were kind of this nuisance law. Yes, they cost a bunch of money for postage, but they didn't necessarily have a real substantive effect on security policy. I think that's going to change.
Yeah, and the other thing, just to tag on to that, I've been telling people for years now, and I think this is continuing the trend, that information security, cybersecurity, used to dominantly be about the technology, and knowing which checkboxes to check in order to have the right amount of security in your systems. And I think what this is, one of my big takeaways from the episode here is that actually the law is starting to overshadow, in some ways, the technological dimension of information security and cybersecurity. I mean, it's really nosing its way into information security affairs, and so it seems like that's just going to continue. And certainly with what I'm seeing is people actually expecting that the whole privacy domain and the information security domain are going to converge. I don't know about that entirely, but certainly, the law and the legal dimension is growing. And I think if you're a cyber risk manager, an information security leader, you really have to reconcile yourself to this and get up to speed.
I agree. You really have no choice.
So I guess CISOs of the future will be, in fact, bar-admitted attorneys and not systems people.
Yep.
Well, I don't know about that exactly. I don't know when that might happen, but okay, this is a great update, and I hope this helped our audience. So I think that wraps up this episode of the Cyber Risk Management Podcast. Today we talked about the rather substantial changes to the Washington State data breach law. One important thing that we didn't actually touch on. Let's do this before we go. Jake, when does all this take effect?
Oh my gosh, we did almost forget. So all these changes take effect on March 1st, 2020. So
okay, so that's not too long from now.
It is only about 9 months.
Yeah, as we record this episode. Okay, everybody, get busy, and we'll see you next time.
See you next time.
Thanks for joining us today on the Cyber Risk Management Podcast. Remember that cyber risk management is a team sport and should incorporate management, your legal department, HR, and IT for full effectiveness. Management's goal should be to create an environment where practicing good cyber hygiene is supported and encouraged by every employee. So, if you want to manage your cyber risks and ensure that your company enjoys the benefits of good cyber hygiene, then please contact us and consider becoming a member of our Cyber Risk Business Strategy Program. Find out more by visiting us at cyberriskopportunities.com and newmanlaw.com. Thanks for tuning in. See you next time.